Testing. Testing. Testing 1, 2, 3. All right, we're going to get started. This is the Electoral Board of the Village of Sauk Village. We have myself, the mayor, as chair. We have Trustee Burgess, who will serve as the substitute village clerk. He is the second senior trustee. And we have Rosie Williams, who is the senior trustee. Trustee Burgess, please call roll.
Mayor Hanks.
Here.
Derek Burgess. Here. Rosie Williams.
Here.
All right. Move to item number 3. We have the adoption of rules. And I'm going to ask the attorney, Luke Keller, to take it from here.
Thank you, Your Honor. At this time, we need a motion to adopt the rules of procedure. Just a little background, these are just standard rules that have been adopted by the Cook County Board of Elections, the Chicago Board of Elections, and the State Board of Elections. So at this time, it would be proper just to have a motion to adopt said rules. Pardon? Yes.
I make. We have a motion. I will second. Trustee Burgess, please call roll.
Mayor Hanks.
Yes.
Trustee Williams Begg.
Yes.
Trustee Burgess, yes.
At this time, I'm just going to ask you to sign an executed copy. Each member sign it so we have an official. We've also give out copies to each of the parties. We have an executed copy. We can move on to the next item on the agenda, sir.
All right, we have the call of the docket. We have Anderson versus Williams. Docket number is SVMOEB-01.
Okay. All right, first we're just going to have just an introduction of the parties. Maybe we start with the candidate.
Sure. My name is Ross Seckler, S-E-C-L-E-R, appearing on behalf of the candidate, Debbie Williams, who is present here today.
Okay, ma'am, could you just state your name for the record?
My name is Francine Anderson, and I filed an appearance to do first thing.
Okay, and you are the objector, ma'am?
Yes, I am.
Okay. Perfect. And I believe we have an appearance for both Ms. Anderson and Mr. Seckler as well? Okay, thank you. Next, we're just going to have an introduction of the Electoral Board exhibits. I'm going to read them off. Exhibit A will be the objector's petition. Exhibit B will be the call. Exhibit C will be the nomination papers. Exhibit D will be the agenda. Exhibit E will be the service of the objections. And Exhibit F will be the rules of procedure. Do we have a motion to accept all the Electoral Board exhibits?
So moved.
Mayor Hanks.
Yes.
Trustee Williams Begg.
Yes.
Trustee Burgess, yes.
Okay. Next on the, do we have any motions on behalf of the objector or the candidate?
The candidate has prepared a motion to strike.
Could you just speak into the microphone?
I apologize. We have prepared a motion to strike and dismiss the objector's petition, which we are prepared to file instanter, as well as notice of filing in service of same.
Okay, you provided extra copies for the objector as well as the...
Yes.
Okay.
I didn't quite hear everything. You said you
We've prepared a motion to strike and dismiss the objector's petition, which we are prepared to file instanter. I have extra copies of same. I can provide to a copy to the Electoral Board as well as one to the objector.
Okay.
Providing I can copy to the objector now. I'll approach.
Yes. Okay, thank you. Okay, what I've been handed is candidate's motion to strike and dismiss objector's petition. With regard to the objector, ma'am, this is an expedited schedule, so normally we give a couple days for the objector to respond. Would you like time to respond to the motion to strike and dismiss?
Yes, I do need time to respond.
Okay. Would Friday at noon be suffice?
No. Friday is not available time. Friday at 7 p.m.
I think we at least need to get that within village hours, the time frame of the hours, ma'am, would
What would be the problem with 7 p.m.? That's the time of our regular meetings.
no, ma'am, this isn't for another meeting. This is just to file your if you have a response. No, we will not have a meeting that day. No, not on Friday. No. This is just you will be able to either fax it or email it to within the rules on the last page. There's an email address or a fax of the firm, which you would.
Friday at 5 p.m.
Okay.
On my road.
Not a problem. Does that work with?
We don't have an objection to that.
Okay. Will you guys need time to respond to that?
If we could have a brief period to file a new reply, would be helpful. I mean,
Speak up.
even if it's Monday or that Tuesday.
Okay.
Yeah.
Um, We do a 20. Could you turn it around by Saturday? Would you be able to do that?
Yeah, no problem.
Okay. So we're going to have the candidate reply 5 p.m. Friday. Excuse me, the objector. And then the response 5 p.m. on Saturday. Okay. Okay, so the response will be 5 p.m. Saturday. Okay. The only other thing we have, we do need to recess to a specific date and time. Originally, do you have a motion?
Yes, sir.
Yes.
I have a motion that I would like to frankly to have Rosie Williams recuse herself because she is the daughter of the candidate, and I don't think she can be fair or market in this transaction of the Electoral Board. I'm asking her to do that willingly. If not, I have a motion.
Okay. Are you good? Did you the notice of motion? Will you be filing that in Stanter? Today, will you be filing that today? The motion? Okay. Do you have extra copies? Do you not have copies?
No. And I was in favor of whatever copy you want.
Let me see your
This is an affidavit. All right. Copies, are you gonna, any copies of that one? Will you need time to respond to this, sir?
Yes, we would like to be able to read it and respond.
Okay, okay. Okay, we'll have to give you a copy of this, we'll have to make a copy of it. Yes, we'll have to make a copy for the board.
If it's easier to just email it after these proceedings today, that would be okay, but
My notarized copy is not emailable. You just have to put down the notary. A couple of documents, it's a legal document.
well, if that copy is scanned and emailed, perhaps we could.
Okay, we could scan and email it after this and get copies to
Either
the
way.
members as well as the candidate.
Thank you.
Okay, so when we would like time to respond to that, before, right?
Why don't we do Friday? Yeah.
Okay, Ms. Anderson, would you, we'll give you a Saturday at 5 p.m. to respond to that? Okay, originally try to have the reconvene Saturday morning at 9 a.m., but it looks like we're going to have some overflow given the time to respond. Would Monday at the same time work for all parties to reconvene?
Can we do Tuesday? Tuesday at the same time? Monday, Friday?
Saturday night?
What time? What time Saturday?
Saturday night? Talking about midnight? That's inconvenient. Probably be Saturday night, he's just responding on that. That's not convenient.
I think Monday at 6. Does that work for the members of the board?
That's fine.
So we're going to have it Monday at 6 o'clock.
I hear the attorney for the candidate say that that's the time.
That would be fine.
Okay. So do I have a motion to recess until Monday? Just something exactly. Monday, January 9th at 6 p.m.
Mayor Hanks?
Yes.
Trustee Williams Bay?
Yes.
Trustee Burgess? Yes. You got it.
Okay.
We're going to reconvene the case number SV-MOEB-01. Trustee Burgess, please call roll.
Mayor Hanks?
Here.
Trustee Williams Bay?
Here.
Trustee Burgess? Here.
Turn it over to the attorneys.
Good evening. The first order of business is the objector's motion to recuse Rosie Williams. We have received since then, on January 6th of 2016, we received a response to the motion to recuse from the candidate, Debbie Williams. We have reviewed the motions and the motions to strike. And at this time, Mr. Chairman, I'd like to explain the law. There are only 3 statutory recognized reasons for that an appointed electoral board member should be disqualified pursuant to the election code. That's 10 ILCS 1-10.9. The three reasons are, number one, if you're running for the same office. Number two, if an electoral board member holds a pecuniary interest in the outcome. Black's Law Dictionary defines pecuniary interest as an interest which involves money, monetary, or something financial. It's been evaluated in the terms of money. The third reason is that when a member of the electoral board will be required to serve as a necessary witness in the objection proceedings. Not one of these reasons exists in this manner. Statutory and case law provided for recusal if a board member has a pecuniary interest. There is no allegations of pecuniary interest or that have been met in this instance. Also, or if a board member is to be called as a witness in a relevant matter of the objections. The objection here solely relates in regards to to Rosie Williams, relates solely to an alleged debt, which is not a legal basis for a challenge to appear on the ballot. Therefore, there are no grounds to recuse anyone in this matter. Mr. Chairman, it would be proper at this time for a motion to deny the motion for recusal of Rosie Williams.
I'd ask for a motion to deny the recusal of Rosie Williams.
So moved.
I got a motion, is there a second? Second. Trustee Burgess, please call the roll.
Mayor Hanks,
Yes.
Trustee Williams Bag,
Yes.
Trustee Burgess, no.
Okay, motion carries.
The next order of business is the candidate's motion to strike and dismiss the objector's petition. Mr. Seekler is here for the candidate. The candidate is pro se. It would be appropriate at this time for Mr. Seekler, to make an argument. And then after he's done with his argument, Ms. Anderson, you are welcome to respond. And Mr. Seekler would then respond to you.
Thank you. My name is Ross Seckler, S-E-C-L-E-R, appearing on behalf of the candidate who is also present here before this honorable board and this evening. The motion to strike and dismiss is relatively comprehensive, but there's some few things to point out and highlight for this board. In particular, and I think the key to focus on is that even if every single thing could be that is alleged in the objector's petition, even if every single thing could be true, it does not amount to a valid objection to the candidate's nomination papers. It's that simple. The objector relies on essentially an outdated form of the statute that's cited in her response and in the objector's petition itself. The statute in question, 65 ILCS 5/3.1-10-5B, it's the part of the Illinois Municipal Code discussing an arrearage of a candidate being in arrears in the payment or indebtedness due to the municipality. The objector cites the Sincus case. It's an Illinois Supreme Court case. It's quite famous. But since that case, the law has changed, and specifically, the law has changed to say that now a person is not eligible to take the oath of office for municipal office if that person is at the time required for taking the oath of office in arrears. That means that the legislator specifically added that language at the time of taking the oath of office. So even if, and by no means, there's anything in the objector's petition which you get to, there's anything in there actually allege a debt or an arrearage in debt or anything that's objectionable to the nomination papers of the candidate, the key is even if that were all true, even if there was a debt, it's not an objection. That's really what I want to present and focus on today. The arrearage, and we further, the candidate has submitted, cited a number of cases in particular. There's some Circuit Court of Cook County, and this afternoon we sent courtesy copies via email, and I don't know, I have hard copies in case the board didn't get them in time, the objector didn't get them in time, but essentially there's the case of Donahue and Biggs versus the Municipal Officers Electoral Board of the town of Cicero and the Circuit Court of Cook County. There was a far more egregious case of what was alleged and what was done, and the key to that, the holding in that case, is that whether true or false, if a debt has not been adjudicated and judged, if it hasn't been assessed, and in particular, noting the language in arrears on a debt, you can't just, it's not just owing something, it's being in arrears, it's being past due. Not one thing in the objector's petition makes even the faintest allegation that there could be a real arrearage in debt. This cannot proceed beyond this harassment act. Then very, very briefly, because these two issues have been so well settled, there's a lot of litigation in electoral board matters and a lot of litigation for nomination papers and a lot of different gray areas of the law, let's say. But these two issues raised by the objector's petition are so well settled that it just shows the frivolous nature of this objection. First, the name issue, I'll call it. Talking about the candidate's name is being Deborah or Debbie or William, however the candidate's name is placed on her nomination papers. The statute is quite clear about how, in particular, 10 ILCS 5/10-5.1 talks about a candidate's designation of name. This isn't an issue where the candidate is using a political slogan like, Debbie lower taxes Williams or something like that. That's not what we have here. It's not what was alleged. That's the only basis for these kind of objections. There isn't an issue of title. It's a frivolous objection. It's not a non-objection, and it should be stricken. Then the notary issue, we've provided a plethora of case law and electoral board decisions discussing issues of the alleged notary issue that was raised about notaries signing petition sheets as well. And this is a settled issue of law. And as such, it should be stricken and dismissed. And overall, in the objector's response to this motion, at no point is there ever a scintilla of legal argument that even addresses the legal deficiencies in the quote objector's petition. This is completely frivolous. This is based on zero legal basis, and this matter should be dismissed with prejudice. And we have also requested attorney fees be assessed. Thank you.
Ms. Anderson.
I know we just committed frivolously. Anderson herself is a notary, and Ms. Anderson does not notarize her own signature. That is part of becoming a notary. You take an oath and you send in your verified signature as a notary that you will not notarize your own signature. When the candidate decided that she would notarize the same sheet that she signed her signature to, but she had a different notary sign other sheets, was just something that she overlooked. This is not a frivolous case. This is a case where the candidate was assumed that she had no responsibility to the citizens of Sauk Village to complete and do it correctly. Maybe there is no case law. Maybe it is. But what I have found is that I know that the exact same oath I took, she should have taken to be a notary. And if she continues to do that, then I am sure that she will be costing the village of Sauk Village more money. And this is
I think I'm okay.
Okay, Mr. Chair, I reviewed the objector's petition. There are 17 allegations, which contain 17 allegations in it. I'd like to address each of the allegations, and then at the end, we'll ask for a vote. Objector's allegations number 3 through 11 allege that the candidate owns money to the municipality, and therefore she's not ineligible and not qualified as a candidate and should not have her name on the ballot for the consolidated election of April 4th of 2017. She has cited the wrong law. She has relied on the Sinkus case, which stated that you could not run for office if you have a debt to the municipality. However, in 2013, the legislature changed that law and said that a person is not eligible to take the oath of office for a municipal office if that person owes money to the municipality or is in arrears, okay? That does not affect their eligibility to be on the ballot, only to take the oath of office once elected. Now, so the motion objection is not valid. There are no valid factual allegations that, even if true, would support a finding that the candidate was in arrears. And there are no ascertainable amounts. And per the circuit court case of Donahue, a non-reimbursed personal use of town resources is not tangible evidence, and it does not make an indebtedness due to the municipality, okay? And you must have tangible evidence, not abstract, which is dependent on speculation and allegation of unsubstantiated record. Now, allegation number 12 states that the name of the candidate on the statement of candidacy is inconsistent with the rest of the documents. I'd like to draw the board's attention to exhibit number G, which is the statement of candidacy, which she states her name to be Debbie Williams. And if you look at group exhibit number H, which is on the next page, she also states that her name is Debbie Williams. There are no allegations that this is a violation of the election code. 10-5.1 of the election code states that a candidate may designate her name on nominating papers if this was any different, or with their given names, their initials, or a nickname that a person is known by, or a combination thereof. Okay? And it may be used in addition to the candidate's surname. Therefore, the use by the candidate of the name of Debbie Williams is not a violation at all of the election code. Allegations number 13 through 16 are allegations regarding the notary. Okay, the allegations specifically are that a notary cannot notarize a petition that the notary signed. And number 14 and 15 are that the notary cannot, or that you cannot notarize your own petitions, that Ms. Williams could not notarize her own petitions. And that number 16 is that on sheets 1, 2, 3, and 4 were all notarized on the same date and by the same notary who signed the petitions. Okay. In regards to our legal opinion, the Chicago Election Board has uniformly held that nominating petitions cannot be invalidated solely because a notary was also an elector. A candidate may notarize his or her own petition sheets that have been circulated by another person. Because the notary in question is administering oaths to the circulator, there is no legal basis for the notary to be disqualified from also signing one of the petition sheets of their elector. In regards to allegation number 17, there's numerous allegations here, but it appears that there's really no substantive allegations or objections. What, in number 17, the objector simply objects to numerous people. She objects to David Hanks, to Deborah Williams, to Rosie Williams, to Trustee Burgess, to Edward Myers, Edward Myers objects to Linda Washington House, objects to the law firm of Odelson and Stirk, but then states they have no objections to certain other trustees. Okay, this violates, there's no allegations in this objection, okay? This violates section 10-8 of the election code, which states that the objections, that the function of the board is to determine whether the nominating papers are valid. So allegations of political bias or speculation are misplaced. Political bias and speculation are not a basis for the allegations. Therefore, based on that, Mr. Chair, it would be proper at this time for a motion to grant the motion to strike and dismiss the objector's petition.
That's for a motion to strike and dismiss the objector's petition. Is there a motion to approve? That motion, is there a second? Second? Trustee Burgess, please call roll.
Mayor Hanks.
Yes.
Trustee Williams Bag.
Yes.
Trustee Burgess, no.
Motion carries.
Also, Mr. Chair, at this time, it would be proper to make a motion. I don't find at this time any basis for attorney's fees. There would be a motion to deny attorney's fees to the candidate at this time.
I'd ask for a motion to deny attorney fees to the candidate at this time.
To the candidate or to the objector? The candidate attorney requested attorney's fees to cover his fees for the proceedings.
To come from.
From the objector.
Right, that's what I'm saying.
Oh, I'm sorry, yeah, that's what I was asking.
So we have a motion to deny their request. Is there a motion to approve?
So move.
Second. Trustee Burgess, please call roll.
Mayor Hanks.
Yes.
Trustee Williams Bag.
No.
Trustee Burgess, yes.
Motion carries.
With that, all matters before the Electoral Board have been completed. Ask for a motion.
I'd ask for a motion to adjourn.
So moved.
We got a motion, is there a second?
Second.
Trustee Burgess, please call roll.
Mayor Hanks.
Yes.
Trustee Williams Bag.
Yes.
Trustee Burgess, yes.
Meeting adjourned.
Oh, I'm sorry, Mr. Chair.
Yes.
We do need to recess this to another date so that we can render the decision.
Okay.
May I suggest either next Monday evening or whenever it's convenient for the parties? I'm sorry, we need a motion to.
I need a motion to reopen the hearing.
So move. Second.
I got a motion and a second. Trustee Burgess, please call roll.
Mayor Hanks.
Yes.
Trustee Williams Bag.
Yes.
Trustee Burgess, yes.
All right, so we're going to ask for a recess, but hang on, we have to.
If I may make one suggestion that might help everyone, in other similar proceedings, both parties have waived the formal in-person service of a decision, instead of having that written decision being served via email or whatever method is best chosen by the parties, which makes it just easier if any party is going to seek court relief and review of this. It's just kind of easier so not everyone has to come back, but it's just a suggestion I figured I would make before the debate.
So, Mr. Sackler, do you waive you and your client's appearance at the signing of the order?
We do.
Ms. Anderson? Would you like to be here? Yes. Okay. And Mr. Sackler, is it okay if we use your email? Email me.
That's fine, or I will.
So we need to determine a date that is convenient for all parties to come back to present the order of the election.
The board meeting next Tuesday.
Monday fine?
What time? Because I do have something to do on Monday. What time? 6:30 until.
We could be here at 6.
I'm just going to sign, correct?
Right.
Is the building open Monday?
Okay.
Because there's no other objections or anything, it's just finalizing it, so.
Right. And rendering the opinion of the.
We don't have to vote on anything. do we?
Is the building open on Monday?
Oh, it's President's Day.
No, it's Martin Luther King's. Martin Luther
I
King's.
didn't get my calendar up yet, so.
Yeah, no, the building's not open,
No.
but it's not open now.
Yes.
Yeah. That's fine with me. I mean, because the building's not open now, we just opened it. I mean, it's just going to be, okay.
Is that okay with you, Ms. Anderson? Tuesday at 6 o'clock?
Tuesday, 6
Sorry, did you say Tuesday?
Yes,
Okay.
Tuesday, 6
Is that okay with you?
So I'd ask for a motion to recess until next Tuesday, which is January, what is it?
17th.
January
17th.
17th at 6 p.m. here at the Village Hall. Ask for a motion to recess.
So moved.
And a motion and a second. All in favor, say aye. Aye. Motion carries.